I'm Alex Kleanthous. I'm going to talk to you today a bit about unfair dismissal. Whether you're an employer who is looking to dismiss an employee or perhaps has dismissed an employee and want to know whether that's a fair dismissal, or whether you're an employee who has been or is being dismissed and you want to know whether your employer is doing it right. I'm going to run through the main points on unfair dismissal. First, let's get some terms straight. Unfair dismissal is a statutory concept created by Parliament and is different from two other concepts which are often mentioned: wrongful dismissal and constructive dismissal. Wrongful dismissal is breach of contract. Generally, an employment contract has a notice clause, and provided the employer complies with that notice clause, for example, giving the employee the month's notice they're entitled to, the dismissal won't be in breach of contract. Constructive dismissal is where the employer has acted in such a bad way towards the employee that the employee is entitled to treat the contract as ended and walked out. For example, if the employer doesn't pay the employee is entitled to say, right, I'm going to treat myself as being dismissed and leave. It may be then that the employee has rights to either wrongful dismissal or unfair dismissal. So what is unfair dismissal itself? Well, in certain circumstances, if a dismissal is not fair, if it is unfair, the employee may have a right to claim compensation from the employment tribunal. Some types of unfair dismissal are what are called automatically unfair. For example, a dismissal because of pregnancy, because of raising health and safety concerns, because of undertaking trade union activities will be automatically unfair. But mostly, an unfair dismissal will be unfair if the employer hasn't followed the correct procedure for a dismissal. The first and crucial point to note is that an employee can only bring an unfair dismissal claim if they have 2 years continuous employment. Now, continuous employment is a slightly complicated topic in itself because it can cover, for example, working for previous employers who are connected, or if the employment has been transferred. But broadly it means if you've worked for an employer for 2 years, then you can bring an unfair dismissal claim. In fact, if you've worked for slightly less than 2 years, perhaps a week and a day less, you still might be able to bring an unfair dismissal claim. So the actual date of dismissal and the way in which somebody is dismissed is absolutely critical. So, assuming that an employee does have the right to bring unfair dismissal, what are the possible grounds? Well, for a dismissal to be fair, it has to be for a potentially fair reason, and the employer has to have followed an appropriately fair procedure. The fair reasons for a dismissal, there are 5. They are capability, conduct, redundancy, illegality, and some other substantial reason. Capability is about whether the employee is doing a good enough job. Is their work up to standard? Have they got the skills and experience and knowledge and ability to do it? Conduct is, as the term implies, about their behaviour and conduct and actions. Have they done anything that justifies dismissal? And it could be anything from persistent lateness to stealing from the employer. Redundancy, again, a fairly obvious concept, not always quite as obvious as it seems. There are some technical definitions of redundancy, broadly a reduced requirement for workers to do a particular job in a particular place. Illegality, if, for example, the employee doesn't have or no longer has the right to work in this country, then it will be illegal to employ them, and it will be therefore likely to be reasonable and fair to dismiss them. And then the 5th category, a catch-all of some other substantial reason, if there is a good enough reason otherwise that doesn't fall into any of the 4 first categories. So the employer has to show, firstly, what is the potentially fair reason for dismissal, and then the employer has to go on to show that they followed a fair procedure. So, for example, if it's capability, it's quite likely that the employer needs to have taken the employee through a performance improvement process, likely with warnings, through an increasing levels of disciplinary sanctions, a warning, a final written warning, and then eventually perhaps dismissal. Similarly with conduct, it's not all misconduct that is going to justify dismissal. Is the conduct serious enough to justify dismissal on its own, what's often called gross misconduct, or have there perhaps been previous issues for which an employee received a warning, a final written warning, and which eventually ultimately justify dismissal? For redundancy, the employer has to go through a proper consultation period to consult with the employee about the reasons for the redundancy, whether there are any suitable alternative roles or other ways in which redundancy can be avoided. Illegality will often require much less in the way of consultation because the facts are often quite cut and dried. And even some other substantial reason, depending on what the reason is, may well require some sort of discussion, consultation or whatever. So the burden is generally going to be on the employer to show that they had a potentially fair reason and that they followed the appropriate procedure. If an employment tribunal decides that an employee was unfairly dismissed, the employee will then be entitled to compensation in principle. There's a basic award, which is a calculation based on the employee's age, length of service and salary. And then there's a compensatory award, which broadly aims to put the employee in the position they would have been in if they hadn't been dismissed by, for example, replacing their income for a certain period. But that's capped at the lower sum of either an employee's annual salary or a statutorily fixed figure, which at the moment is in the region of about £89,000. There are also questions about whether the sum should be reduced because of the employee having contributed to their own dismissal in some way. It's by no means unknown for an employment tribunal to decide that an employee was technically unfairly dismissed, but their behaviour was such that they're not entitled to any compensation for it. Quite often an employee doesn't have just an unfair dismissal claim, but may also have other overlapping claims. Quite typically these might include discrimination. The employee might say that not only were they dismissed unfairly, but the reason for it was discrimination on grounds of age, race, sex, etc. Or the employee might have claims for breach of contract, which can also be brought in certain circumstances and up to certain limits in the employment tribunal. They might tack on a claim for failure to give written reasons for dismissal or failure to give a proper written contract. These are all claims that can be brought in conjunction with an unfair dismissal claim. I hope that was useful to you and gave you what you needed. But if you've got more questions, if you'd like some more advice, please do not hesitate to get in touch with us using the details below.